Hello students, welcome to EPG Pathshala. I am Dr. Mandeep from Guru Nanak Dev University, Amritsar. Today we are going to talk on the module Legal Environment from the paper Business Environment. After completing this module, you should be able to understand the concept of legal environment of India. Describe the objectives of various laws affecting the business in India. You will be able to learn the basics of various laws available or enacted in India and will be able to interpret the terminology relating to the legal environment affecting business in India. The code of conduct, which decides the legal boundaries of the business, is known as legal environment. So our business is regulated in the country by the government as per well-defined priorities. So legal environment of the business keep on changing as per the need and demands of the business, government and the consumers. Legal environment constitutes the various laws which are passed by our government in any country to regulate the country's business operations. All the decisions in the business are dominated by regulatory environment. A business should have a thorough knowledge of laws and legislations of the government, as non-implementation of policies may lead to heavy fine and penalties. So there are a number of laws which are regulating our system in India. Some of the laws which affect the business in a direct sense are mentioned. Industrial legislation affects a large number of industries, workmen and their families. Hence, a large population of the country is affected by industrial legislations. Traditionally, the employer used the policy of hire and fire to his workmen, but now the concept of master and servant has changed. The employer may hire the employee but cannot fire at own will. The legislation protects the rights of the employees. Industrialization in India or in any other country means factory system growth with employers and wage earners. Wage population migrated to industrial town due to the introduction of factory system, and the society faced labor problems which need solution. Earlier, the workers were illiterate and unaware of their rights, and the employer's socio-economic status was above the employees. Hence, the workers could not dictate their terms and conditions relating to the working hours, wages, leave, etc. To promote the social justice, there was a need of equitable distribution of profit. So the another objective was to provide protection to their health against harmful effects. Some of the labor laws are like Workman Compensation Act 1923, which ensures that the compensation to be paid to the workers in case an injury is caused by accident during the course of employment. Act provide adequate protection to the workers from the losses by accident and improve employers' working conditions. In case of any injury to the workman due to the accident, the Act provides for the payment of compensation to certain class of employees. Another act relating to industry is the Trade Union Act 1926, which ensures better conditions of employment to the workers, and trade union concept has grown up. In any industry, labor and capital contribution is very essential. To secure better amenities, privileges, and working conditions to the labor through collective bargaining, strikes, and mutual insurance are used as the tools. Another one is Employees State Insurance Act 1948. That is to ensure the social security to workmen. It aims to provide economic and social justice to the poor labor class and extend to the workers of every factory and industry. Minimum Wages Act 1948 prevents exploitation of labor and aims to fix minimum wages which an employee must get. It protects the ignorant, less privileged and less organized workers to be protected from the capitalist. Minimum wages ensures the physical need of the workers to keep them above the starvation level and provide certain level of educational, medical requirements, etc. Apprentice Act 1961 regulates the training of apprentice in an industry. Act was passed to ensure a systematic training program for the skilled labor and provide facilities to ensure training as per the programs. Next comes the Factories Act 1948, which clearly deals with the provisions of health, welfare, and safety of the workers. As per the Act, there must be cleanliness in the factory and the precautions to be taken for accumulation of dirt, and it should be removed daily. Every workroom floor is to be cleaned regularly, and the promotion of human conditions at workplace, securing full employment to the workers and welfare of the people are covered in the Act. The last act under labor legislation is Industrial Dispute Act 1947, which was passed with the objective to maintain industrial relations through industrial peace and economic justice. If there are good relations between management and labor due to the absence of disputes, then there will be positive influence on the production. It will promote smooth growth of the industry. Hence, industrial peace can be maintained through the legislation for industrial relations. Now, coming to taxation laws, there are two types of taxes. We all know, that is direct taxes and indirect taxes. Direct taxes are those taxes which are directly charged from the person who is availing the benefit of the product, while the indirect taxes are those taxes which are passed ultimately to the consumer of goods but collected from the seller or importer or producer, etc. Income tax and wealth tax are direct taxes, while central excise duty, custom duty, central sales tax, VAT, service tax are indirect taxes. Now, first of all, we shall talk about direct taxes. Income Tax Act 1961 provides for the administration, levying, collection and recovering of income tax in India. To replace Income Tax Act 1961 and Wealth Tax Act 1956, Government of India drafted a statute named as Direct Tax Code. Income of the person who is resident in India during the previous year is chargeable under Income Tax Act. There are 5 heads of income known as income under the head salaries, income under the head house property, then capital gains, income under the head business or profession, and the 5th one is income from other sources. The indirect taxes. First of all, Central Sales Tax Act 1956 is an indirect tax and is chargeable by central government from the registered dealer on taxable turnover of interstate sale of goods. That is, when the goods move from one state to another, or import and export of goods are not covered under this act. Secondly, Customs Act 1962. It's a law relating to the custom duty to be charged on import or export in the country and is levied by the central government. It contains the provisions for duty chargeable on cargo exports, postal articles, and baggage, etc. It also imposes restrictions on imports and exports. Smuggling activities are prevented by the central government through this particular act. Central Excise Act 1944 is the law related to duty chargeable on goods produced or manufactured in India. On essential goods like alcohol, cigarettes, consumption is discouraged and the duty is charged at a very high rate on commodities like oil and gas to reduce their consumption. It is chargeable from manufacturer for the goods produced in India. Value Added Tax 2005 is a tax on sale and another form of sales tax. During sales of the goods, it is charged at the different stages of transactions and paid on purchases by the buyer. The registered dealer is issued an 11-digit number called Taxpayer's Identification Number, that is TIN, under the law to charge VAT. Intellectual property laws. Human intellect and human mind creation is called intellectual property. It is a hidden property which means to accumulate wealth. Intellectual property has a fear of piracy and covers two branches, that is industrial property, for example patents, trademarks, industrial designs, etc., whereas the copyrights covers writing rights, musical works, dramatic works and photographic works, etc. Patent Act 1970. It grants the privilege or authority to one or more individuals in property which is approved by the government. The government provides an exclusive monopoly for the limited period of time for an invention which is called patent. For the invention, exclusive rights can be enjoyed by the inventor. The government encourages research by innovation, encouragement to promote technological, industrial, and economic development in the country. Patentee is the owner of the patent who can deal with the property in the same manner as the owner of any other movable property. Next comes Trademarks Act 1999. It is related to the fact that a consumer may be cheated when purchasing a commodity, presuming to be original, which is of substandard. The reputation of the trader may also suffer. So, to protect the interest of the consumer and trader, a symbol is marked on the origin of the goods. Such symbol is known as trademark. The trademark may be a brand, a symbol, a letter, which can be represented graphically and may include combination of colors and packaging. Trademark ensures quality of the product and it identifies the product at origin. Copyrights Act 1957. According to this, copyright is a special kind of intellectual property. This right is acquired with a person as a result of intellectual labor, which is called copyright. It protects the work, labor, skill of the person, which is in the nature of musical, dramatic, or literate work, or maybe artistic sound recording work, etc. Another type of law which affect our business, especially in India, is the banking and insurance laws. Indian banking and insurance sector had undergone a bigger change in the last few years, especially after 1991. A bigger amount has been invested in India in the banking and insurance sector in the form of FDI, that is foreign direct investment, because it has been open to them. Although banking and insurance sector is entrusted with the safety of funds of the general public and even of the government institutions, many reforms have been introduced in both the sectors. In the era of globalization, these sectors need a proper regulation. The related laws are Banking Regulation Act 1949, which is, as the name suggests, related to banks and public service institutions which deal in the funds of the public. So the Banking Regulation Act contains various provisions relating to capital of the banks, businesses which are prohibited to the banking companies, liquid assets, banking licenses, new branches of the banking, opening, loans and advances, etc. Successful banking venture depends upon the position of liquidity. So before the commencement of the business, a banking company requires a license from Reserve Bank of India and RBI inspects that whether the position of bank is good to pay the depositors at present or in future. RBI grants prior permission to the banking companies for opening new places of businesses in India and abroad. So banking company can wind up business like any other company if it is unable to pay debts or otherwise. Then we talk about Insurance Act. Insurance Act 1938 is the law related to insurance, and Insurance Regulatory Authority of India is the regulatory body which makes and supervises the development of insurance sector. Insurance is an agreement between two parties. The person who takes protection pay premium is called the insured, and the person who agrees to compensate for the loss is known as insured. Policy is a document in which terms and conditions of the contract are mentioned. There are various types of insurance, maybe life insurance, fire insurance, marine insurance, general insurance, and even the medical insurance. Business and corporate law. There are various types of business and corporate laws which may affect a business in India. Many laws were prevalent in the country even before independence. It includes so many laws. For example, in business law, there's the Indian Contract Act 1872, Sales of Goods Act, then Negotiable Instrument Act, then Partnership Act, etc. So let's discuss them one by one. The first one is Indian Contract Act 1872. It's a law which is most important part of mercantile law. Trade or business is not possible without this. Every person is affected by the law of contract in one way or the other. Every one of us enters into large number of contracts right from morning till evening. As per Indian Contract Act, one person makes an offer, and when this offer is accepted by the other person, it becomes a valid contract. There must be free consent of the parties which are entering into the valid contract. The objective must be lawful and considered as a valid one. For a valid contract, the parties must be competent to enter. There are remedies which are available to an aggrieved party if the other party makes a default in the contract. Sale of Goods Act 1930. It is a law of contract under which property in goods is transferred by the seller to the buyer. Two parties are covered. One is called the seller and another is buyer. Consideration for the contract of sale is money paid or promised to be paid. Subject matter of the contract of sale of goods, which may be existing, future, or contingent good. Performance of the contract of sale is complete when both the parties, that is seller and buyer, complete their promises. Seller delivers the goods and buyer makes a payment of the goods. Next comes Partnership Act 1932. It says that the partnership is an association of two or more persons who have agreed to share the profits for the business concern carried on by all or one of them acting for all. Partnership business is based on the principle of mutual agency, which means that if the decisions which are taken by one partner in good faith, then such decisions are carried on by all the partners. That is, in a way, every partner will be liable for such decisions. The liability of the partners is unlimited. If the debts are not paid, then they can be recovered even from the private property of the partners. So, to remove the shortcomings of Partnership Act 1932, a new act called Limited Liability Partnership Act 2008 came into existence. Now, let's discuss the corporate laws. There are again various laws that affect the corporate houses, and one of them, which is very important, is Companies Act 2013, which replaced Companies Act 1956. But this act came into existence when the corporate sector has undergone a bigger change over the years. A company is nothing but an association of a number of persons having perpetual succession and common seal. It's an artificial legal person having separate legal entity from the persons who constitute it. The property of the company belongs to it and not to the members. One of the biggest advantages of the company is that members have the limited liability, which means in case of winding up of the company, liability of members will be limited to the extent of shares subscribed by them. If the face value of the share is rupees 10 and the shareholder has already paid rupees 7, then he is liable to pay only rupees 3 in case of winding up. Another privilege is that it has perpetual succession, which means that the company is not affected by the death or insolvency of any person. Members may come and go, but the company remains in existence. The company, being a legal entity, is separate from its members, directors, employees, etc., and has certain rights which are not enjoyed by the members. Company can even sue and can be sued in its own name. Company is not a citizen like the natural person. So, to bring a company into existence, certain important steps are taken by the people. They are known as promoters. In the formation of the company, Memorandum of Association is very important document which is the foundation of the company structure. The internal management of the company is managed by another document known as Articles of Association. A company can invite public for subscription in shares or debentures by the issue of prospectus. The shares of the company are freely transferable, being a movable property in the manner mentioned in the Articles of Association. Company can even raise funds through the borrowings, and since being the artificial person, it cannot act by itself. So the persons carry on the business of the company known as directors. Meetings are conducted in the lawful manner, and the company, being an artificial person, comes into existence via legal process and comes to end even by the legal process known as winding up. There are some other laws which may affect business in India. Although businesses are affected by the large number of laws, some of them are uh, being affecting by the other businesses, like Arbitration and Conciliation Act 1996. It mentions that arbitration agreement is an agreement under which, in case of dispute between the parties, the dispute can be referred to an arbitrator. Such dispute may arise due to legal relationship in between the parties, which may be contractual or not. The agreement of the arbitration must be in writing. The parties should sign it, and record of agreement may be through different means of communication like telegrams, telex, or exchange of letters. The number of arbitrators to be appointed by the parties is as per their will, but such number cannot be an even number. If the parties fail to determine the number of arbitrators, then the arbitral tribunal will be the sole arbitrator. On the death of the party, arbitration agreement will not be discharged. In such a case, it will be enforceable by or against the legal representatives of the deceased. To present the case, each party shall be given full opportunity and treated with equality. The place of arbitration is as agreed between the parties. In case of failure to decide the place, it shall be determined by the arbitral tribunal as per the convenience of the parties and circumstances of the case. As per this Act, the conciliation proceedings may be commenced when one party initiates conciliation and an invitation in writing is sent to the other party with the identification of the subject of the dispute. On the acceptance in writing by the other party, there shall be commencement of the conciliation of proceedings. Now, no conciliation proceedings will be there if the invitation is rejected by the other party, if the reply is not received by the party who initiates conciliation within 30 days from the date when the invitation is sent, or the other period mentioned in the invitation, conciliation invitation may be treated as rejected. One conciliator should be there unless agreed between the parties. 2 or 3 conciliators may be there. There may be an agreement between the parties on sole conciliator name in case of one conciliator. One conciliator appointed by each party in case of 2 conciliators. When there are 3 conciliators, one conciliator is appointed by each party, and the third is the person who is agreed between the 2 parties and act as the presiding conciliator. Principles of justice, fairness shall be in the mind of the conciliator, and he shall act in an impartial and independent manner for the speedy settlement of the disputes. Competition Act 2002. It is an act which protects the interest of the consumers and ensures in Indian market a free trade. The purpose of the act is to prohibit those activities due to which the business entities are restricted from competition and free trading. The entrepreneurs are provided an opportunity to compete in the market and ban the monopoly situation. As per this act, there is a restriction on agreement related to supply, distribution, and even the production, etc., in between the persons or associations, due to which the competition in India is adversely affected. There will be an adverse impact on the agreement which determine the prices for sale or purchase directly or indirectly, and due to which a limit of investment, supply, markets and control of production, etc. is set. There are two types of agreements as per the competition law. When the enterprises are competing within same business, then these are called horizontal agreements and they are presumed to be illegal. When the agreements are among the independent enterprises, then these are known as vertical agreements but legal. When an enterprise restricts production directly or indirectly, imposes conditions of discriminatory nature for the purchase and sale of goods, or for the entry of new operators, create hindrances against the benefits of the consumers, then there is an abuse of dominant position which is also controlled by this law. The activities of combination like mergers, amalgamations and acquisitions are regulated by the Act, and it also keeps a watch on the combinations which cause an adverse effect on the competition in the market. Competition Commission of India is an independent entity and body corporate which can sue in own name, possess a common seal and have the power to enter into the contract. Commission consists of a chairperson who works with the assistance of the minimum 2 and maximum 10 members. At present, there are 6 members in the commission. The practices which have an adverse impact on the competition can be eliminated by the commission in order to ensure the trade freedom in the markets in India and protects the interest of the consumers. Foreign Exchange Management Act 1999, which has replaced the earlier Foreign Exchange Regulation Act 1974, that is FERA. To tune with the foreign policy of India, FEMA regulation enables Reserve Bank of India and Central Bank to pass the regulations in the foreign exchange market. Currency is purchased or sold by the individuals, governments and businesses. There may be an exposure of risk or benefit to the country due to frequent changes in the foreign exchange market. Restrictions are imposed by the central government through FAMA when the payments are made to any person outside India or receipts are taken from them in India. There are restrictions on the transactions in foreign exchange and payment from outside country when not made through an authorized person. Necessary requirements are required to be complied with by the exporters, which need to furnish export details to the RBI. Next comes Information Technology Act 2000, which deals with the commitment of crimes where the computer is used as a tool. Computer may be used to commit a crime or they may be computer related crimes. Crimes may be committed without computer even, but computer facilitates commitment of crime in the better way. For an electronic governance legal framework, it is provided in the Act that digital signatures and electronic records are recognized by the Act. Cyber crimes and penalties are also prescribed. Cyber Appellate Tribunal has been established in order to resolve these disputes. The cyber crimes may cover harassment by mails, hacking, defamation, virus transmission, network trespassing, etc., and even the cyber terrorism against government organization or pirated software distribution. In order to cover cyber law security in India, the expansion of the companies in e-commerce has promoted the government to regulate in this area. A very important act is Environment Protection Act 1986, which is related to the protection of the environment in India. Environment may relate to the surroundings, and for progress of society, industry, it is must. And the pollution which is being coming from the industry, there is a need to avoid them. Environmental protection is a global issue nowadays. There is a close link between healthy environment and economic conditions of the community. Due to industrialization, water pollution is created. Industrial waste is discharged by a large number of industries into rivers, and that's why they are being polluted. Even the air pollution is being felt in the form of smoke, heat, dust, etc. And noise is an atmospheric pollution which increases due to urbanization and industrialization. So, in the end of this module, let's summarize what we have learnt. Legal environment. Legal environment of the business is one of the most important aspects related to the business. Although there are a large number of laws which are regulating the businesses in India, this may vary depend upon the business. In order to solve various labor problems in the changing scenario, labor laws are there. Indian Contract Act 1872 is the most basic business law to enter into contract. To regulate the company's form of business organization, there is Companies Act 2013, which was amended from the Companies Act 1956. So, to safeguard the environment, Environmental Protection Act 1986 is working, and to discourage the monopoly situation, we have the Competition Act 2002. Information Technology Act is another law which protects from the cyber crimes. Due to globalization, there is exchange of foreign currency, hence FEMA is working in India. In this reform period of banking business and insurance business, the laws are in operation. In order to avoid cutthroat competition and the cost of other Competition Act plays a very good role. Taxation laws have been formulated in order to balance the social and economic structure of the society. If the disputes are to be settled out of the court, then we have Arbitration and Conciliation Act, which is very helpful to the business. All in all, the government is trying to simplify the legal environment in order to regulate the business as per the demands of the global business world, although all laws cannot be mentioned in the small space here. Thank you.